4.
Muy buenos días tengan todos y todas ustedes que nos acompañan en este conversatorio sobre la restricción de derechos fundamentales en la pandemia por COVID-19. El Centro de Estudios Constitucionales de la Suprema Corte de Justicia de la Nación les da la más cordial bienvenida a este intercambio académico que ha resultado de gran interés para la comunidad jurídica en relación con un problema que nos atañe a todos y a todas y que es una de las fundamentales preocupaciones de toda la humanidad en este momento. Nos acompaña nuevamente el profesor Martin Borowski, catedrático de la Universidad de Heidelberg, Alemania, en esta nueva sesión de este conversatorio con el tema las medidas estatales frente al COVID-19, libertad e igualdad, aportándonos un punto de vista de un sistema jurídico diferente en un país diferente para poder apreciar pues cómo han enfrentado en esas latitudes estas dificultades y este problema que asola a nuestras sociedades en la actualidad. Le cedo entonces el uso de la palabra al profesor Martin Borowski sin más preámbulo, agradeciéndole desde luego su presencia. Muchas gracias, profesor Borowski. Bienvenido nuevamente.
Thank you very much. I'm very grateful for having been invited to give 2 lectures in this series of seminars, or as we now call them, webinars. The first lecture had the title COVID-19 in Germany, an overview, and it was mainly about the properties of the virus and the disease and an overview of the German reactions. Then we had Carsten Becker on Tuesday with remarks on the formal side of the constitutionality of measures. And yesterday, Marie Fuchs with an exposition on federalism. And as was already mentioned, the title of my lecture today is Liberty, Protection and Equality in the Pandemic. So I added protection, which is, so to speak, in some sense understood, but plays an important role, as we shall see. Many states employed bundles of measures, as I shall call them, against COVID-19 and the pandemic, such as social distancing in public life, public and private meetings, the obligation to wear masks in certain situations, requiring quarantine in certain situations, the closure of restaurants, pubs, clubs, concert halls, shops for non-essential goods, churches, sports arenas and sports facilities, schools, kindergartens, and the prohibition of political assemblies. Less intrusive than a full closure or complete prohibition are conditions. For example, church services may remain permitted, but only with distance between persons of at least 1.5 meters. All surfaces must be disinfected after every service. Singing is forbidden, and the Holy Communion, drinking from a common chalice, is also forbidden. Such measures typically interfere with liberty. In the case of a prohibition of church services, or conditions for church services, with the liberty of a church to perform a church service according to the relevant belief and liturgic rules, and the liberty of the member of the parish to participate in a religious service according to the relevant belief and liturgic rules. To use a less religious example, the owner of a pub is constitutionally at liberty, according to the constitutional right to pursue one's business as one wishes, Article 12, paragraph 1 of the German Basic Law, to serve beer and snacks. And the visitors of the pub have the liberty to drink beer and eat snacks at the pub as an implication of their general right to freedom, Article 2, paragraph 1, German Basic Law. A great many different measures were introduced and, over time, repealed, tightened, replaced with other measures, or eased, typically following controversial political debates. Every individual measure in the respective form, tightened or eased, can and should be evaluated with an eye to the severity of interference with liberty and to the extent of protection that it grants against transmitting SARS-CoV-2, the virus. This is to say that there is room for a great many debates on empirical data and on the normative evaluation of the harmful, in terms of liberty, and the welcome, in terms of protection granted, effects of a certain measure. We could now go through typical measures and discuss whether and to what extent the protection granted by these measures justifies the respective interference with liberty. There are lively debates on this issue in every legal system, with an eye to the measures in place or measures that are not in place, but could be, according to some people, should be in place. Alternative measures, we could call them. Going comprehensively and thoroughly through a representative set of typical COVID-19 measures, remember the long list at the outset, would be a huge undertaking. I understand that the next and last lecture today will focus on the right to assembly in times of the pandemic by Daniel Arnulfo Mateos Duran. I have to confine myself to a handful of remarks on fundamental issues. The measures to which I referred to are typically enshrined in law. The first question is, why law? Why do we need measures in the form of law? Why not relying on responsible behavior of the citizens? One could explain the characteristics of SARS-CoV-2 and COVID-19 to the public and explain how one can avoid transmission of the virus. The citizens, as autonomous individuals and responsible human beings, would surely behave in a way that they do not get infected and do not infect others. It goes against human dignity, the argument could continue, to be forced to behave morally by threat of legal sanction. In Europe, Sweden has become famous and eventually, one hastens to add, notorious, for going down that path quite some way. This argument from responsibility against legal measures is, however, idealistic to an extent that it presupposes completely unrealistic assumptions. The reasons why we need measures against COVID-19 in the form of law are the same reasons why we need law in general. I shall mention here only the two main arguments for the existence of law. According to the argument from authoritative cognition, there is no agreed or otherwise shared set of moral norms that is concretized to an extent so that moral rules could easily be applied. We need an authority that establishes concrete norms for human behavior. This is the legislator, endowed with legal authority by the Constitution. The second argument is the argument from effective enforcement. Even if an individual knows what morality requires, it does not follow automatically that this individual acts according to a moral requirement. Immanuel Kant from Königsberg, Germany at the time, expressed this fundamental insight at the end of the 18th century with his distinction between the principium dejudicationis and the principium executionis. Insofar as moral requirements protect the interests of others, we cannot grant complete freedom to act immorally. Morality as such does not provide for coercion, so that moral requirements ought to be enshrined in law, for which institutionalized coercion is characteristic. We cannot tolerate, for example, autonomous moral decisions of egoists who know that they are infected with COVID-19 and consciously meet other people without revealing their infection. Such cases cry for legal sanctions. This is to say that at least a moral minimum of rules needs to be enshrined in law, in general, as well as in the case of measures against the COVID-19 pandemic. Recent real-world experience for this is that the Swedish way of dealing with the pandemic in the first months in 2020, focusing on responsible behavior rather than binding law, is perceived as failed. For Sweden's death rate during this time was simply too high. To refer to responsible behavior in addition to legal rules, not instead, in addition to legal rules, does have, however, a certain point. Legal measures tend to oversimplify things. For the required behavior needs to be phrased in clear and easily recognizable form. For example, in Germany, private gatherings, private meetings were and are regulated during the pandemic. According to the middle tier of restrictions over Easter 2021, now the next week, private meetings are only permitted for a maximum of 5 people from 2 households. Assuming your own household consists of 3 people, you can only invite 2 other people from the same household. The reason for this limitation is to reduce social contacts. This is a simple rule, and compliance can easily be determined. If more than 5 people meet, or up to 5 people from more than 2 households, this rule is violated and a legal sanction will come forward. The simplicity of this rule does render it, however, in some senses too strict and in some senses too lenient. On one hand, it is too strict because if you have 3 visitors from 1 additional household and seat them on the balcony, the risk of virus transmission is certainly lower compared to seating 2 visitors in your living room, indoors, owing to aerosols, which are dangerous indoors, but not outside. The risk is also lower when you seat 3 visitors in your living room if all these visitors were fully vaccinated with the BioNTech Pfizer vaccine, assuming that reports are true that this vaccine reduces infectivity to less than 10% of the normal risk. On the other hand, the rule is too lenient, for this rule does not take into account sequential meetings. You can invite as many people as you like, provided that at any given point in time, there are never more than 5 people from 2 households in your flat. Having 3 groups of 2 people each from 1 household, respectively, in your flat sequentially. For example, 2 people from 9 to 10, the next 2 people, other people, from 10 to 11, and the third group of 2 people from 11 to 12, means that you generated 18 social contacts of people from different households, while in the case the permitted case. While in the case of 3 visitors from one household, the forbidden case, at one point in time, you generated only 9 such social contacts. This means that a behavior generating 9 social contacts violates the rule, while another behavior generating 18 social contacts is in conformity with the very same rule. With an eye to limiting social contacts, it would suggest itself to give every person a daily limit of social contacts. But how could police enforce this? How could they know whom you've met before on a certain day? Just as tax laws, legal measures against COVID-19 inevitably leave some loopholes. One can only hope for responsible behavior beyond the limits, hope that people do not exploit such loopholes to an unreasonable extent, and responsible behavior by a significant part of the population may well make the decisive difference in the fight against the pandemic. This is why the German government regularly appeals to responsible behavior with quite concrete advice, and I support such appeals wholeheartedly. In some instances, it has not, however, become clear why the government refrained from certain legal rules and instead appealed to responsible behavior. If rights of others are at stake, then in general, legal measures should be enacted. What is more, the decisions of the informal rounds of the federal government and the state governors coordinating COVID-19 measures in Germany's federal state are not binding law and not phrased in formal legal text. Rather, the measures are typically reported in TV programs and in the press. In many cases, it is not easily recognizable which rule is enshrined in law and which rule is only a non-binding recommendation. This can only be properly distinguished by looking at the formal legal instruments that are forthcoming a couple of days later, something that very few citizens actually bother to do. Now that we have established that there needs to be legal measures, we might take a closer look at the tension between liberty and protection. There are 2 standpoints from which you can view this tension. One can take the standpoint of liberty. For example, a church facing conditions for religious services, as explained above, distancing, no singing, no Holy Communion, may decide to go before the courts and finally file a complaint to the Constitutional Court. They claim that their religious freedom has been violated. In assessing the claim stemming from religious freedom, the Constitutional Court will determine whether holding religious services according to the Church's religious doctrine has been interfered with, which is the case. The court will continue to assess whether this interference is proscribed by law, which requires that the interference can be based sufficiently on a parliamentary statute. Finally, in assessing proportionality, the 3-pronged proportionality test will be applied. Suitability requires that the legislator pursue a legitimate end and that the means must be appropriate to achieve, or at the very least, to promote that end. The protection of life and health of others against harm by COVID-19 is a legitimate limiting reason. A measure against COVID-19 is precisely a measure because it realizes or furthers this legitimate limiting reason. This reflects the teleological or consequentialist nature of designing measures against COVID-19 that I emphasized on Monday. The prohibition of singing, for example, reduces aerosols, thereby limiting the risk of transmission of COVID-19. According to the criterion of necessity, the means employed must have the least restrictive effect. This is to say that there's no alternative means. Finally, proportionality in its narrow sense requires that the interference with the individual's right and the promotion of the limiting reason be balanced. If the interference outweighs the limiting reason, the interference counts as disproportionate and therefore unconstitutional. If the limiting reason outweighs the interference, or if both exhibit equal weight, a stalemate case, the interference does not count as disproportionate. In the context of proportionality analysis, let me emphasize briefly two important issues. First, there are structural and normative reasons why the democratically legitimated parliamentary legislator enjoys a certain extent of discretion in assessing the criteria of proportionality. The practical implication is that the Constitutional Court is only empowered to perform limited review of the proportionality judgment of the legislator, not strict review. Put simply, the Constitutional Court must refrain from declaring parliamentary statutes unconstitutional as long as the balancing judgment of the legislator is at least plausible, or in the even more limited version of limited review, not arbitrary. One can disagree with a certain result, but still regard this very result as plausible or non-arbitrary. This limitation of review is weaker for regulations, actually, enacted by the administration. For the democratic legitimation, the main reason for epistemic discretion is merely indirect rather than direct. Consequently, the relative immunity of parliamentary statutes is stronger than that of regulations. Here, the distribution of competences between the legislator and the administration may well have substantive implications. Second, a judgment on proportionality is only as good as the reasons that are explicitly put forward on behalf of the results, particularly the reasons for the balancing judgment. A court that assures that it has gone through the process of balancing the constitutional right as the limiting reason and gives only the result without any justification has done little. We know that the constitutional right and the limiting reason are competing formally at equal rank in the hierarchy of the legal system. So one must outweigh the other, or there must be a stalemate. And even in a stalemate case, there is a definitive outcome. A mere result without justification reflects the formal authority that judgments of this court enjoy in the legal system. But nothing has been done to even try to convince those who might disagree with this result. The formal authority of judgments must be complemented with substantive authority that emerges from convincing arguments, an explanation which arguments are convincing and which are not, and in both cases, why. So legal argumentation is key. And I might mention that Alejandro Navarro from Mexico, INACP, has recently published a book on legal argumentation, Argumentación Jurídica, that I very much recommend to your attention. Coming back to the process of assessing claims stemming from liberty rights, determining the scope of the prima facie right, for example, what does religion mean, and has there been an interference with religion, and proportionality analysis in the justification of the interference, can be performed for every measure in the bundle of measures. Political activists claim freedom of assembly, churches claim religious freedom, owners of pubs, restaurants, hotels claim freedom to pursue their business as they wish, constitutionally protected, and so on. Typically, in assessing, for example, the church's claim to religious liberty, the court will only evaluate the specific measures limiting the exercise of religion, and the same applies mutatis mutandis to the court cases of the owners of pubs and restaurants and political activists, and so on. It seems that these different competitions, the interferences with different rights on one hand and protection of life and health of the population on the other, are separate competitions, and each can be assessed on their own. In some sense, this is true. In some sense, it is not. This becomes clear if one takes the other standpoint, the standpoint of protection. Since the 1970s and the 1980s, constitutional rights to protection have been part and parcel of the German doctrine of constitutional rights. These rights to protection are not based on specific provisions focusing on vulnerable minorities or something like that. They are based on the very general insight that every interest undergirding constitutional provisions traditionally understood as recording liberty rights may also give rise to protection, positive rights. This doctrine of rights to protection has also found acceptance at the European level of the protection of fundamental rights. This is a rather different category of positive rights compared to social rights, which are economic rights, while rights to protection also protect the liberty of the individual. While liberty rights, negative rights, require that the state refrains from interfering with the individual's liberty, rights to protection require the state to do something to protect against harm to fundamental interests of one individual by another private entity. These rights to protection are an integral component of the reconstruction of Drittwirkung, or in other words, horizontal effect of constitutional rights. Owing to these rights to protection, it is not only state action that may be regarded as unconstitutional, also state omission can prove unconstitutional. To be sure, definitive constitutional rights to certain state action are quite rare, for the conditions are very demanding. Where the interest at stake has high abstract weight, where there is a clear and present danger, to borrow the phrase from North Your Border, for this interest, when the individual is unable to protect him or herself, and where it is in the legal and factual power of the state to grant protection, a definitive right to protection is at least imaginable. Remember that for older people, an infection with SARS-CoV-2 is very realistically a matter of life or death and causes significant morbidity for many people, and that life and health are very weighty interests of the individual. Admittedly, everyone can do something to protect him or herself. For example, wear a mask or refrain from meeting people. Be that as it may, the majority of people have to earn their living by means of being employed and have to commute to and from work with all the social contacts this implies. If you were the only person to wear a mask, an infection is much more likely compared to the situation in which everyone wears a mask, because the state made it compulsory. In that sense, collaborative behavior is far more effective than individual behavior. What is more, the state generally has the power to make wearing masks mandatory by means of law. The case for definitive rights to protection is particularly strong for very vulnerable people in circumstances in which they cannot realistically provide themselves for effective protection. For example, old people in care homes. Admittedly, this general power of the state is limited by the liberty rights of those who are, in the example, forced by means of law to wear masks. It is a characteristic of rights to protection that the realization comes at a cost in terms of liberty. While the protection of life and health is a limiting reason for liberties, these liberties are, the other way around, limiting reasons for the protection of life and health. The competition between liberty and protection is symmetric. This symmetry gave, early in the German debate on constitutional rights to protection, rise to misgivings that the democratically legitimated parliamentary legislator is placed in an awkward position. For rights to protection require them to interfere, and liberty rights require them not to interfere. The legislator's position is not, however, so awkward, for discretion works both ways. Discretion has to be considered from both the standpoint of liberty as well as from the standpoint of protection. There are measures for which the legislator may plausibly assume that enacting them does not violate liberty rights, while not enacting them does not violate rights to protection. These measures are inside the room of discretion. The Constitution does neither require nor prohibit them. Here, the policy of the democratically elected parliament will prove key. Coming back to the protection that the state owes to the individual in the pandemic, prohibiting or limiting the spread of COVID-19 requires a significant reduction of the number of social contacts, particularly a reduction of dangerous forms of social contacts. Remember huge indoor gatherings as superspreading events. Since there are a great many different forms of social contacts in modern societies, a single and isolated measure, for example, closing concert halls, will have very little, if any, effect on the spread of the disease. Rather, a comprehensive bundle of different measures is required to bring down the overall number of social contacts significantly. This is why there are these typical long lists of various measures, which I sketched at the outset of this lecture: social distancing, wearing masks, quarantine, closing restaurants, pubs, clubs, concert halls, shops for non-essential goods, churches, sports arenas, schools, kindergartens, prohibiting assemblies. An effective reaction on the part of the state to the pandemic requires that a comprehensive bundle of individual measures be employed. Every individual measure contributes to a certain reduction of the number of social contacts. An individual measure is a part of a greater whole, the comprehensive bundle, and its individual effectiveness may actually depend, on a certain extent, on which other measures are employed or not employed. Strictly speaking, such synergistic or antagonistic effects among individual measures in the comprehensive bundle, the greater whole, need to be taken into account in assessing the measure, even from the standpoint of the liberty right, but of course also from the standpoint of protection. What is more, the comprehensive bundle of measures can achieve the same reduction of social contacts with different lists of individual measures and different forms of such measures. For example, a conservative government may view religion very favorably and hesitate to interfere with religious life. Then, ceteris paribus, a greater reduction of social contacts in other areas must be achieved. Stricter measures for political assemblies could make up for the shortfall of reduction because of sparing the exercise of religion from being interfered with. Of course, one may argue precisely the other way around, favoring political activities over the exercise of religion. In the German debate, there has been quite some agreement that keeping kindergartens and schools open must be a high priority. To be sure, whether this high abstract, this priority, is required by constitutional law or is a political decision inside the framework of the Constitution but not required by it, is not completely clear. At any rate, from the standpoint of protection, the degree of protection that is provided by the comprehensive bundle of measures proves decisive, as long as no liberty right is violated. Designing this or that individual measure as more lenient or more strict raises, of course, the issue of equality. Equality is, however, in its own dimension a function of constitutional rights compared to liberty and protection. I will return to the issue of equality shortly. Summing up the section on constitutional rights to protection of this lecture, considering the nature of the COVID-19 pandemic, rendering social contacts dangerous, there is an arguable case that the state is under a constitutional definitive duty to enact legal measures that limit the transmission of SARS-CoV-2. If Germany had not enacted any legal measure for limiting the transmission of the disease, with the government in denial of the facts and claiming that COVID-19 is only a harmless flu, that will simply go away soon, and that it is rather a hysterical opposition and fake news, which are the true problem, not the disease, I have no doubt that the German Constitutional Court would find a violation of the constitutional right to protection stemming from Article 2, Paragraph 2, Clause 1, German Basic Law, the constitutional right to life and health. What is more, even if the state enacted some half-hearted bundle of measures falling below the constitutionally required minimum of protection, the Constitutional Court would precisely say that. At the end of the day, doing nothing or doing too little are only two forms of an omission to enact the constitutionally required minimum of protection. At the end of the day, the evaluation what this constitutionally required minimum of protection in a given set of circumstances actually is depends in good part on the facts, how dangerous is the disease in terms of infectivity and the mortality and morbidity it causes, which forms of social context are precisely how dangerous. This is why we desperately need solid scientific data. Once we have the facts, the situation must be evaluated from the point of view of constitutional values and principles. One thing is sure, the constitutionally required minimum depends also on the circumstances. For example, an older population needs more protection than a younger population. What is more, if new variants of SARS-CoV-2 exhibit higher infectivity and higher mortality and morbidity, more protection will be constitutionally required. And this reflects the current situation in Germany, where the British mutant B.1.1.7 has largely taken over. It is not without reason that Angela Merkel very recently referred to this very fact by claiming that the British mutant is actually a new virus and the resulting illness a new pandemic. Since my first lecture 3 days ago, cases in Germany have been accelerating more and more, and the next couple of weeks look bleak. There will be another, the third hard lockdown soon. The last section of my lecture is devoted to some remarks, brief remarks on equality. The most fundamental distinction with an eye to the right to equality is the one between the right to equal treatment and the right to equal results. There is a tension inside equality broadly conceived, since equal treatment often aggravates or creates different results, owing to differences of various sort, which are simply a fact in human societies. And arriving at equal results requires uneven treatment. This is the famous paradox of equality, as it is called in German constitutional law. For example, closing schools will deprive all pupils equally of the education that the state provides. It is easier for pupils with wealthy parents to make up for the resulting gap in education. The pupil with wealthy parents will have a new computer, a good internet connection, a quiet room on his or on her own to study, and one of the parents may well be not forced to work and simply be at home, assisting and supervising the pupil in his or her learning effort. By contrast, pupils with poorer parents will have an old computer, if any, no or slow internet access, have no quiet space in the family's flat, and parents will probably both be forced to work long hours. In that sense, the pandemic aggravates social inequalities. that are already existing. If you want to mitigate this factually unequal situation, you need to improve the learning situation of poorer pupils by means of giving them, for example, computers, decent internet access, and the like. You need uneven treatment. There are good reasons to assume that constitutions grant some minimum level of factual equality as a definitive constitutional obligation or even as a constitutional right, but combating factual inequality beyond that constitutionally required minimum is a matter for the democratic process. Social, economical, or otherwise factual inequalities are also aggravated by the pandemic at the international level, at which more wealthy countries were and are more successful in securing supplies of scarce goods, which are crucial for combating the pandemic. At the beginning of the pandemic, this was personal protective equipment, PPE, then the resources for PCR testing and quick tests, and now finally vaccines. The unfortunate result is that this tendency even aggravates differences in wealth, because successfully limiting the pandemic in your country does not only protect public health of your population, it also limits the detrimental effect on your economy. We talked a bit about that in the discussion after my lecture on Monday, and it is indeed a topic in and of its own. Let me only say that there is an incentive for wealthier countries to contribute to the fight against the pandemic also in less wealthy countries. The higher the numbers of infections, the higher the risk that more dangerous variants of the virus will emerge. Every copy of the virus is a lot in the lottery of mutating towards potentially more dangerous variants. There is the danger that such more dangerous variant spreads to the population of a wealthy country that has already vaccinated the whole population, its own whole population, and that the vaccines used here have not achieved immunity to the new dangerous variant. With an eye to equal treatment, the German Constitution records the general right to equal treatment in Article 3, paragraph 1, basic law. This is to say that there is a prima facie obligation to treat people equally, unless there is a sufficient justification for treating people differently. This obligation aims at the administration, equal application of the law, and at the legislation. Statutes and regulations have to be designed in a way so that people in equal situations are treated equally, and people in different situations differently, taking properly into account the respective differences. Insofar as there are legitimate limiting reasons for treating people differently, some form of balancing, akin to proportionality balancing, between the prima facie right to equal treatment and the limiting reason takes place, the so-called new formula. For example, if the state wants to discourage the use of fossil fuels because of environmental protection, there may be financial incentives for environmentally friendly forms of individual transport. This may make petrol cars more expensive, discriminating against those who use such petrol cars. This discrimination may well, however, be justified owing to the contribution to the reduction of carbon dioxide. Coming back to the pandemic, the problem is that the virus creates a very powerful argument to prevent social contacts. Basically, every social contact, but particularly the dangerous forms of social contacts. You cannot, for example, run a concert hall the way we have been used to for centuries, cramming people together indoors in tight spaces for hours, where social contacts are an integral component of social, political, or economic activity. The virus represents a legitimate and strong reason to suppress that very activity for the time being. Whole industries such as hospitality, pubs, restaurants, hotels, performing arts, or shops for non-essential goods have been basically closed for a year with only short periods of modest part opening. These industries are economically devastated with all the implications for those working in these industries. By contrast, industrial production is running more or less normally in Germany, and employees in the public sector continue to receive their full salary. In some sense, one might say that it is the virus that discriminates. It kills far more old people than young. It kills more men than women. It economically devastates industries that rely on social contacts, not other industries. The virus is a tiny passive particle of genetic information that enslaves human cells to reproduce the virus and then die. Metaphorically speaking, we might say that it is guilty of cell slavery. To be sure, the virus is not a human being capable of forming an intent, good or bad, or the will to survive. It is not a proper addressee for legal norms such as the prohibition of discrimination or the prohibition of slavery, if you want to use this metaphor. We cannot declare the virus unconstitutional for a violation of constitutional provisions and expect that the situation changes owing to that declaration. The virus is a part of nature. It just happens to be there, and it does not answer to any form of ought. We simply have to accept that the pandemic as a natural disaster happens, do not deny the facts, and try to distribute the burden in society as equally as possible without compromising the success of these comprehensive bundles of measures against the pandemic. The fact that the industries which heavily rely on social contacts are hit harder by measures against the pandemic is simply inevitable. What can be done is mitigating the economic impact by state subsidies for industries that are particularly affected. Germany is admittedly relatively wealthy and has thrown basically huge amounts of money at the industries that suffered most. This spreads the burden more equally, for the money for the subsidies has to be raised at the end of the day by means of taxation, which affects the whole population. Considering the huge amounts of money needed to make a real difference, even wealthy countries cannot do that for a long period of time. If the vaccination campaign succeeds in effectively ending the pandemic in Germany at the end of this year, and the economy goes back to full steam in all sectors in 2022, the national debt will have risen sharply, painfully sharply, in 2020 and 2021, but without rocketing to unsustainable levels. Without vaccines, the economic situation, however, would be really desperate. And this is from the standpoint of a wealthy country. Of course, it's worse if you're less wealthy. A future challenge with an eye to the liberty, protection, and equality will be vaccination. I have, with an eye to the time, to keep the whole thing brief. In Germany, currently, no difference is in terms of being subject to measures is made whether a person is vaccinated or not. The restrictions are simply the same. The overall mood and the political rhetoric is that there can be no privileges for vaccinated people. This is a fundamentally mistaken view, and we need a far more informed debate on this problem at some point in the future, and it's beginning to emerge. Probably not before everyone has received a realistic offer to be vaccinated. If exercising freedoms is made dependent from being vaccinated, injustice in the prioritization of vaccination is being aggravated by privileges only for those vaccinated. There are legitimate debates on whether the current vaccine prioritization is just, but the focus is rightly on speedy immunization of as many people as possible, not on protracted debates on perfect priorities. I should not, however, use the expression privilege for the exercise of constitutional freedoms in the case there is no ground for interference. This is not at all a privilege. It is what the state has to respect unconditionally. What is more, we need more data to what extent vulnerability to infection and infectivity are reduced by vaccination. And, oh my, this may well be different for different vaccines. And to complicate things further, for different variants of COVID-19. This is to some extent parallel to natural immunity following an infection with COVID-19. If both infections, vulnerability to infection and infectivity are reduced by 10%, and if the values can simply be multiplied, virologists will tell us whether or not, the risk that a fully vaccinated person infects another fully vaccinated person falls to 10% of 10%, namely 1%. If this is true, and unless I miss something important, which may be the case, I simply do not see how you can justify to prohibit meetings of fully vaccinated persons from the point of view of liberty. The different infectivity and vulnerability to infection compared to unvaccinated people then is the crucial difference that justifies different treatment from the point of view of equality. If, however, vaccines prove less effective, paradigmatic superspreading situations might still prove problematic. Thank you for your kind invitation and your kind patience. Thank you.
Muchas gracias, profesor Borowski, por esta interesante exposición en relación con las medidas que se han tomado en Alemania contra el COVID-19, el SARS-CoV-2, y esta situación que estamos viviendo en la humanidad. Muchas gracias por sus interesantes puntos de vista y los diferentes aspectos en los que nos ha explicado pues, algunas de las esenciales vertientes de este fenómeno para el derecho constitucional y los derechos fundamentales. Bueno, pues tenemos distintas preguntas, numerosas preguntas del público, tanto de redes sociales como de otras vías por las que se está transmitiendo esta conversación. Estoy casi seguro que por su número va a ser imposible desahogar todas, contestar todas. Así que voy a tratar de enfocarme para plantearle a usted, profesor Borowski, las más fundamentales y para tratar también de conjuntar en lo esencial a la mayoría de estas preguntas que coinciden en aspectos fundamentales, de modo que haciendo una formulación general de estas cuestiones podríamos responder pues a varias de las inquietudes de las personas que nos están escuchando y viendo en este momento. Bueno, la primera pregunta se refiere a alguna de las ideas iniciales de su exposición cuando habló de el fundamento y la necesidad de medidas preventivas en esta situación de pandemia. Habló usted de que no existe un conjunto definido y consensado de exigencias morales y por eso son necesarias las medidas jurídicas. Ahora, nos preguntan del público que si, habiendo esta variación en requerimientos morales, no habría entonces el mismo problema o la misma posibilidad de que existan diferentes interpretaciones de una medida jurídica concreta en relación con esta prevención de la pandemia.
Yeah, okay, thank you. I get the point. In some sense, the they need sometimes the legal form of a measure makes things better, because we have the text of a legal provision, which is authoritative text, and we have methods of legal argumentation. And I mentioned legal argumentation in my lecture actually already in another context actually. So, and there are the well-known canons of interpretation. There is the wording. And of course, when it comes to measures against COVID-19, there is purpose, the purpose of the measure. And the purpose of the measure may well guide the interpretation to some extent, but only inside the frame that is established by the language of the legal measure. Being a lawyer, I immediately admit that, of course, there may be some different interpretations, there may be some debates on how to interpret legal measures, but there is far more clarity and certainty from legal measures. So that would be the core thrust of my answer. The advantage of legal measures is, once we have a legal measure with a certain text in place in the legal system, we need interpretation, but actually what the meaning of this legal instrument will be is fixed to a great extent. And the debates and uncertainties in interpretation are a concern in law, but far less than in the case we would only rely on morality.
Muchas gracias, profesor. Tenemos otra pregunta que me parece que es uno de los puntos clave de toda nuestra conversación. Y algo a lo que usted se ha referido en varias ocasiones a lo largo de su plática. El papel de la justificación científica y lo que usted ha llamado datos científicos sólidos. Desde luego que es innegable la función que tiene la ciencia para la toma de decisiones de carácter político y jurídico. Ahora, un punto importante, sobre todo al comienzo de la pandemia, hace aproximadamente un año, es qué hacer cuando no existen estos datos científicos sólidos, o son precarios o débiles los datos científicos que existen en torno a un problema de salud, como justamente sucedió al inicio de esta pandemia. Cómo en particular tomamos este elemento o cómo juega este factor al analizar la proporcionalidad de las medidas preventivas frente a la diseminación de una enfermedad como la que estamos enfrentando. Gracias.
Well, yes, thank you. It's a very good question. One example occurred to me in reaction to the first question, if I may just continue briefly. I mentioned this German rule that if there are gatherings, there may be no more than 5 people from 2 households. And for example, legally, as a lawyer, I was asking myself, what actually is the precise definition of a household? Because it may well be, in Germany, it is the case that many families who have daughters or sons who are studying at a university in a different city. These students can be formally registered at the university, or they can be formally registered priorly with their parents. Now, it's both possible, most often. And this is a sheer formality. Now, a person may actually be the whole time at university having student parties and then coming back home, but formally might count as being member of the household, while from the purpose of the rule, this makes no sense, because this is a person that has been living far away for quite some time, had social contacts with other people. They had not. So there is actually merit in the first question. But then again, we have to deal with this by the canons of legal interpretation. And then, as I referred to the purpose, there is, I think, an idea how to deal with this problem. Now, the second question, scientific data. Uncertainty at the beginning. Yes, there was uncertainty at the beginning. We know more than we knew initially. And very clearly, mistakes were made. Mistakes were made. Europeans thought at the beginning, I mentioned this on Monday at some length, they thought masks are useless. They don't help. It was initially thought that smear infection and droplets cause infections. Aerosols were not seen as the main problem. And then obviously mistakes were made. This is something I think everyone openly admitted. And even virologists made these mistakes. They were advising the government. And it was not that politicians were not happy to listen to scientists. Scientists did not knew the characteristics of this new disease. So you can go wrong. But well, this is what happens. The only thing is you need to try to base your measures on the most solid scientific data you have at the relevant point in time. And everyone knows that there is no perfect certainty. You have the idea that the magnitude of effects is this or that, and then you go without perfect certainty in that direction. But the problem is, what should we do? We are living in a world that is full of facts around us, and we cannot deny empirical reality, because if we try to do so, our measures against COVID will be pointless because they do not take account of the true and proper characteristics of the disease. So you always have to try to get the best data you have at the time. If that changes, people say we were wrong, that's to some extent fine. And actually citizens to some extent have to accept that they were subjected to measures that proved at the end of the day unsuitable, or something like that, that they suffered interferences with the liberty that were actually pointless because there was no positive contribution to the fight against the disease. There's not much we can do about that. The problem, of course, is, well, it's not so easy that you ask one expert and one expert tells you what is true. You have different experts from different schools, and they are debating among themselves. And you, as a politician, as someone who designs measures, you have to kind of to take a meta perspective, and without being an expert yourself, you have to try to judge which interpretation is the most convincing from your non-expert point of view. And this is the responsibility of politicians. And of course, you have to ask yourself, well, is this actually some renowned scientist who has been working for years and years at a public institution, is not particularly interested in money or wealth, is just devoted to science? And on the other hand, you might have someone from a recently established undertaking, which may well be influenced by money, for example, and political interests. So you have to get a sense of your own experts and basically try to trust those what the majority says or what strikes you as the most solid advice. The question, to what extent empirical premises, this is what these are, empirical premises, which they play in balancing, they definitely play a role, because if the positive effect of a measure, that a measure helps against the disease, if this is uncertain, then this uncertainty of the empirical premises weakens that principle in the balancing. And typically, that the interference with liberty, this is certain. if you know a restaurant has to close for a year, there is a rent, there are employees. Now, you know if the restaurant will have to be closed for 1 year, this restaurant is basically gone. It's bankrupt. It's there no more. The room is still there, but no restaurant. It's gone. Now, that harm is certain. And certain damage, but for achieving uncertain effects means that in balancing, the weight of the limiting reason is reduced. And if our knowledge actually increases and if we get more certainty about the positive effects, on the other hand, the other way around, if the uncertainty goes down, more certainty, the value of achieving these positive effects in the balancing rises. This is, I think, the most basic effect of differences in certainties. Yeah, thank you.
Muchas gracias, profesor. Creo que este es uno de los puntos más críticos, más decisivos no solamente de la validez de las medidas relacionadas con el COVID-19, sino en términos generales y utilísimos de todo el examen de proporcionalidad. Este papel fundamental que tiene la certeza en las premisas de la argumentación del test de proporcionalidad, que puede darnos lugar a muchísimas variables de resultados, a consecuencias muy diferentes, aunque estemos hablando del enfrentamiento de los mismos principios constitucionales en diferentes situaciones, claro está. El punto que usted acaba de tocar, relacionado con este aspecto epistemológico, epistémico del test de proporcionalidad, en relación con la pregunta que se había formulado sobre la solidez de los datos científicos que se utilizan en el test de proporcionalidad en general y en la valoración de las medidas contra el COVID-19, creo que nos lleva a la siguiente pregunta, pero quería yo conectar lo que usted acaba relacionar lo que usted acaba de decir con una idea que ha sido formulada desde hace, o que se dice que ha sido formulada desde hace muchísimo tiempo, supuestamente por Kant. La idea de que nuestra necesidad de decidir, tomar una resolución sobre algo, excede o va más allá de nuestra capacidad de comprender el problema y esto que estamos hablando. Es una frase que se atribuye y se cita muchísimo en Alemania, atribuyéndosela a Kant, precisamente en esta situación de la urgencia de decidir algo en situaciones de mayor o menor incertidumbre. Y esto se relaciona con lo que usted acaba de decir, por supuesto, y se conecta frente a las afectaciones graves, intensas, que se pueden ocasionar a valores y principios constitucionales de gran relevancia, por ejemplo, como la libertad religiosa. Las restricciones que se han implementado a lo largo de este tiempo de pandemia, en particular, por ejemplo, frente a la libertad religiosa, pues nos lleva a advertir la posibilidad, la restricción y la limitación de un derecho fundamental tan importante, tan relevante para la sociedad, aún para quienes no tienen un credo, una creencia religiosa, pueden reconocer con facilidad la importancia de esta libertad en una sociedad democrática. ¿Qué podríamos reflexionar, por ejemplo, en torno a este conflicto que existe entre la necesidad probable, posible de salvaguardar, proteger la salud de las personas frente a la totalmente cierta afectación que habría a otros derechos fundamentales, especialmente a la libertad religiosa y en concreto a la clausura de iglesias y la prohibición de servicios religiosos. Muchas gracias.
Well, thank you. This is a very fundamental question. I agree wholeheartedly. Let me, for the sake of clarity, say you quoted Kant, who is famous for his philosophy, maybe less famous for his philosophy of law, arguably, and not famous for being a lawyer. Why do I mention this? I mention this because there are, of course, different perspectives at looking at a problem, a normative problem. We have to solve a normative problem, and we realize we do not have sufficient data to come up with the perfect solution of the normative problem. Now, if we are members of a seminar in philosophy, we are very much excited and we really go into the most problematic issues and we try to find the best possible solution. At the end of the seminar, the semester is over, we realize we have found three new answers for every, three new questions for every answer we found, and we are actually more confused. And we decide it's now time to have a break, do some holiday, and we continue with the problem with the next philosophy seminar. And now the professor in philosophy may come to the conclusion, after having done this for 20 or 30 years, there may not actually be an end to that process. Of course, I'm oversimplifying things. Apologies to my colleagues in philosophy. I want to make a very simple point, but to make this point as powerfully as possible. In law, it is a virtue that we come to a decision, and the decision can, because the decision has to be made in relatively short time. As a judge, there is a question put before you. There's an application, and then law has to be applied, and you have to answer basically yes or no. And you have limited time. You can push back actually the file for some time, but there are limits to it. You have to give an answer. And so because lawyers are not by, this is so to speak, in the DNA of law as a social institution, that there have to be decisions. And even the point that Radbruch emphasized at some points in his legal philosophy very powerfully, in some sense, even if we have no idea what the answer is, often it is better to give an answer, even if it is the wrong answer. The wrong decision is better than taking no decision, because certainty comes into play. Now, I touched on this a bit when I mentioned the two sides of authority of a judgment, the formal authority and the substantive authority. I'm a fan, as you have realized, of substantive authority, of legal argumentation, explaining your results as good as possible. But just only that there is someone who takes the decision already has a virtue and is a virtue in and of itself. And to some extent, the same, we are talking here about measures enacted by the parliament or by the administration. But the same in this urgent situation, when a pandemic comes, applies to the legislator. The legislator has to give an answer. If the legislator says, okay, we set up a committee, and this committee invites, guess whom, philosophers, to explain the problem in terms of political philosophy to them, then this committee may have a report after 5 years or so. By that, half of old people are dead. Children have suffered from this inflammatory syndrome, and some of them have actually are crippled for life, maybe. Some others have suffered long COVID. and so on, and all the damage has been done. Something has to be done. And so the problem in terms of the competition between liberty and protection is, if you do nothing, you risk to do the wrong thing. If you do too much, you risk to do the wrong thing. There's always a risk in everything what you do. If you err on the side of liberty, you may be wrong. If you err on the side of protection, you may be wrong. If you choose a middle way, it is very likely that you are to some extent wrong, but it is very unlikely that you are completely wrong. And so from that point of view, I think one can only expect in terms of law from judges when it comes to judgments, but also in urgent situations from administrations and from legislators. You can only ask of them to take the best possible decision relative to the empirical and normative knowledge. There's uncertainty in terms of facts, but also to some extent uncertainty of how do we balance actually competing constitutional values. So the best possible decision at a time when you have to take the decision, because otherwise significant harm is evolving. This is all we can ask of lawyers. And so this is, in some sense, this is a problem, and we always risk to do the wrong thing. But if at the time the decision was taken, it was very reasonable to do what we did at that time, I think this is still, in some sense, still the correct decision. Even if, this is of course the question we have to ask ourselves, is this actually now wrong or not in some sense? But this is challenging, and I agree that this is a huge problem with the pandemic.
Muchas gracias por su respuesta, profesor. Esta situación que, bueno, implica la necesidad de tomar medidas que pueden ser deficientes por omisión, por no tomarse, o excesivas precisamente por tomarse, como usted indica, sin una adecuada reflexión, sin una consideración detenida de las afectaciones y perjuicios que tienen las personas, pues puede llevar a situaciones en que resultan perjudicadas distintas personas en distintos intereses, inclusive en sus derechos. Uno de ellos, esto bueno, lleva a la reflexión de que si bien es necesario considerar los otros derechos de otras personas, cómo definimos el límite de las medidas que pueden afectar los derechos de las personas para salvaguardar la salud, como en este caso, o cómo justificar la validez de estas afectaciones, estos derechos. En particular, creo que esto se ha traducido en algún momento y en algunos países, no sé si exactamente ese sea el caso de Alemania, pero en algunos casos en Estados Unidos, por ejemplo, en que las personas sienten vulnerado su derecho a la libertad religiosa o su derecho al libre desarrollo de la personalidad, su libertad en general, como se ha señalado en Estados Unidos, por ejemplo, por estas medidas restrictivas. ¿Cómo justificar estas afectaciones desde el punto de vista de una persona, por ejemplo, que no cree en la existencia del coronavirus o que considera que su libertad tiene que ser defendida y si no es respetada, entonces hay una violación a un derecho fundamental a la libertad? Puede ser religiosa, una libertad general en particular. Gracias.
Yeah, thank you. Okay. Now, when we are now looking at we are moving from the side of protection, empirical properties of the virus, of the pandemic, we are moving, so to speak, to the other side. And it is not only the virus that is unknown. It is, of course, also the detrimental effect on those liberties who are interfered with by measures which is unknown. Because in Germany, a situation in which schools were closed for so long, a situation in which children were not permitted to go to the playground, meet their friends, their peers in the same age, there is no experience on that. And of course, there is uncertainty here. And over time, certainty grows. And it is not only virologists and public health experts who need to contribute to designing the measures. It is also experts, for example, on health of children and all other areas which are affected. And in the same way as we have to steer a different course when we realize a measure of COVID-19 against COVID-19 is not as effective as we thought, or needs to be changed to be effective. In the very same way, on the other side, if we realize, for example, at the outset, we thought that closing schools is not so harmful. We just thought, well, their grandparents are so much in danger at the outset, so we just said, well, close the schools. It didn't think much about the consequences. It may well be that over time, it gradually becomes visible that there is actually much more harm inflicted than we initially thought. And the very same way that we have to change our measures if the effectiveness changes, our understanding of effective changes, also if our understanding of the harmful consequences for measures may well change, and this may lead to a different view and a change in the measures, because something that struck us as proportionate, now that we have new knowledge, strikes us no longer as being proportionate, or something we wrote out at the outset as disproportionate now seems to be proportionate. So it can also, the other side can change, definitely. This is the first part of the fourth question. Now, the second part was referring to freedom of religion. Freedom of religion is particularly difficult because we have to do something that at the outset seems like squaring the circle. Why? Because a belief, at the end of the day, a belief is to a certain extent objectified, because religions have personnel, they have holy writings, they have a tradition, they are socially institutionalized entities. So it's not just a person. But at the end of the day, a religion relies very much on beliefs. And constitutionally, we tend even to protect individual beliefs inside bigger religious communities. So even the dissident, so to speak, in religion is constitutionally protected. Now the problem is, if we balance interferences with religion, the fact that religion at the end of the day is a very subjective phenomenon, we cannot simply allow a religious person to take the balancing of constitutional rights and limiting reasons from his or her very individual religious perspective. Why? Because others may be harmed. Because the virus may spread in a church service, the people go shopping, go somewhere else, and they transmit the virus they have received to other people. So there's harm to others is at stake. And this is why we have to make a kind of transmission from the subjective urgency that something is really required from a religion, and then a state judge. The balancing has to be undertaken by the state because rights of others are at stake. Now, the judge has to, so to speak, objectify this subjective phenomenon religion, so that it can be, so to speak, calculated, computerized, so to speak, in the objective decision of an objective organ. Now, if someone basically says, I do not believe in the coronavirus, this is all made up. Now, if a religion gives rise to that statement, fine, everyone is fine to believe what he or she wants to believe, but I do not really see why this would force us in law to say we grant definitive protection to live a life as a member of the whole secular society, being in contact with secular society and demanding that only this religious position is the only one that the state authorities have to accept. This is simply not true. It may be a matter of freedom of expression. We can discuss that, whether it is permitted to say that or protected combined by expression and religious freedom. But that then the state is forced to act accordingly is, I think, a long shot. I don't think that this is particularly convincing. And that sometimes people claim that their rights are violated, while from our secular perspective, we come to the considered and well-reasoned conclusion that the rights are not violated, is something that unfortunately happens. There are, of course, you can imagine, there are restaurant owners in Germany who claim that it's unconstitutional that they have to close, and that they are perfectly able to run a scheme according to which no one will get infected in the restaurant, which is very unlikely. But of course, they claim that this is disproportionate and a violation of their economic rights to economic activity. And I don't see actually why we should listen more if structurally the same situation is here at place, while religion is a bit different with a subjective objective distinction. But at the end of the day, that people complain if they are not happy with the result is something we know, don't we? Okay. Thank you.
Muchas gracias por su respuesta, profesor. Muy importante este aspecto de la diversidad y la pluralidad de puntos de vista en una sociedad democrática y el punto de vista común que se debe tener en ella. En relación con estas inquietudes de, por ejemplo, actitudes como yo no creo en el coronavirus o tengo derecho a no usar cubrebocas, la máscara, como se le conoce en otros países, podría existir, como existe o se ha reconocido en el ámbito de la responsabilidad civil, podría existir desde el punto de vista constitucional un deber general de cuidado de las demás personas. Existiría esta obligación a cargo de otros ciudadanos como una suerte de eficacia directa de ciertos derechos fundamentales, una suerte de Drittwirkung que funde este deber de cuidado. Gracias por su respuesta.
Yes, it is. And this is, in some sense, the upshot of the characteristics of the constitutional right to protection that I outlined in the lecture. There is, the expression may be coined with some modest and kind provocative intent, whether there's a right to take care of other people, because basically, no, because everyone can take care of him or herself. But the rights to protection are an acknowledgement that there are contexts in which people cannot help themselves. They are in situations in which they are, their interests are endangered and they cannot protect themselves against the dangers. If they can protect themselves, the state doesn't have to do anything. And this kind of liberal, or in some sense libertarian, approach holds true. So this is not actually an invitation for the state to regulate everything. It basically, everyone should care for himself, and own initiative should be rewarded. But there are situations in which the individual cannot take care of one's own interests for whatever reasons. And then in that limited sense, in that qualified sense, there is to a certain extent a right to take, or an obligation to take care of other people. Now, this is abstracted in the German tradition to the state, where the state is available. This is why the constitutional right to protection is not a right against another private individual, that the other private individual doesn't do anything to me. No, it is a right to the state, that the state prohibits the other individual to do something to me. So it's directed towards the state as the representation of everyone, so to speak. There is a context, and there's, I think, a difference, at least between the European continental tradition and the Anglo-Saxon tradition. In Germany, in criminal law, you have the Good Samaritan Law. And this is also an expression. This is, and you can see this to some extent actually as a reflection of rights to protection, interestingly. That was there traditionally in criminal law before actually rights to protection technically were acknowledged in the debate in constitutional law. So the normative core of this very idea that you take care of others when they can't do this for themselves is deeply rooted, at least in the continental European tradition. And this Good Samaritan Law basically says if there is a kind of accident or an emergency, and someone is in need without being at fault for being in need, and someone else comes and can help without sacrificing significant own interests. Of course, you don't have to share water and then both die. So this is not asked of you. But if you can, if it's factually possible, you cannot simply say, well, I hate you anyway, and I'm happy to see you die now because I don't like you, and it'll go away. This is, it would be criminal. It's 323C. Everyone law student knows it in criminal law, and it's the Good Samaritan Law. And as far as I'm aware, in Anglo-Saxon societies, it's far less understood, but I'm not an expert on that. This is just, so to speak, what I got from living in the UK for a couple of years and listening to the debates there. Yeah.
Muchas gracias, profesor. Muy interesante esta comparación y reflejos de principios que hoy reconocemos en el ámbito constitucional, pero que han sido en realidad desarrollados desde el derecho ordinario como el derecho penal y la ley del buen samaritano a los que se refiere, y la responsabilidad civil como en otro ámbito jurídico. Regresando ya, saliéndonos un poco de estos temas generales y volviendo a los temas específicos relacionados con la pandemia, es claro, todos lo sabemos, que la pandemia ha ocasionado una gran cantidad de perjuicios en muchos aspectos y en muchas direcciones desde el punto de vista social e individual. Creo que no hay ámbito que no haya quedado sin ser afectado de una manera o de otra. Hemos hablado mucho en estos minutos de derechos de la afectación que han sufrido por las medidas preventivas del SARS-CoV-2. Derechos fundamentales muy, digamos, muy humanos, como la libertad de expresión, como la libertad religiosa en particular. Pero ¿qué podemos decir en relación con las restricciones a las libertades en el ámbito económico y comercial. ¿Qué aspectos particulares usted observa en relación con estas libertades y derechos fundamentales de corte, digamos, menos humanista y más económico y relacionado con los recursos con los que cuentan las personas? Gracias por su respuesta.
Yeah, the economic damage done by the pandemic. First, what always struck me, it still continues to strike me, is the unequal impact. Because often when there's an economic crisis, then the damage is very located or very distributed. Now here it is very much concentrated to those economic undertakings who inevitably rely on social contacts. It is the hospitality industry, for example. A hotel, for example, simply does not work in times of the pandemic. Why? Because, well, in their own hotel rooms, there is no social contact. So if people are in their own hotel room and the hotel room is disinfected, this is not a problem of social contacts, but they have to travel to the hotel. So they have to sit in the train, they have to be in the crowded railway station. There were desperate attempts at the beginning of the pandemic to create some kind of social distancing at airports. And many people who have experienced this told me, who were flying during the pandemic while it was still permitted, said, this is horrible. This is horrible. It doesn't work because there are queues everywhere. There is waiting halls. There is the baggage claim, and social distancing simply doesn't work. Our airports are not built this way. Now, in the hotel, in the breakfast room, at one point during the pandemic, I was visiting a hotel with my wife. We were sitting there in the hotel, and then it came to breakfast. Now, there was an official concept for breakfast that was actually licensed by the state administration that said there is a breakfast concept, breakfast order, so to speak. And the order says, well, people are sitting at the tables and they are being served by waiters. So they are not running around at a buffet. Now, what was there? A buffet. Why? Because they had not enough waiters. It doesn't work. So you can't organize it differently. And then there was the attempt to organize the buffet. And it was Germany, in the heart of Germany. And this was completely mad because no one obeyed the rules. No one understood the rules. They were coming from the table, they were hungry, there was food. This was basically the only rule that applied. And no one obeyed the rules. So some things simply don't work. If it comes to the big industries, for example, the car producers, Volkswagen and so on, they are working basically normally. They are doing some quick tests, there's some testing going on, but at the end of the day, they are in their factories, they have very limited social contacts, and they can produce the cars. So it's this uneven spread. To some extent, of course, you might argue that in setting priorities, because as I mentioned, you can have a comprehensive bundle that is more lenient for religious life or political assemblies, but is then more strict in terms of economic activity. You might argue that it's a better idea to keep social activities, religious activities, political activities up. There's a case for doing that. But then you have people from the industries who tell you actually, we are basically earning the money in this country, because if you enact stricter measures that hamper us, then there is actually measurable economic damage. and they come with numbers and say, the damage, economic damage, is so and so billion euros just for these companies. And this is measurable. And so in this competition between economic activities and social religious activities, the problem is that the damage that is done in terms of education, in terms of religion, in terms of political freedom is not so easily measurable. Now, if you're standing opposite to these business people who tell you, well, you have to close your church, otherwise we have to close our factory, and this is really expensive, then politicians who have to not only to care for religious freedom and social values, but also have to make sure that people are employed and are employed so that they can earn their living decently. It's difficult to take the decision. And so the last aspect I should mention is that it is often said, but this is, again, we have precise numbers and precise data is not easily it's not easy to get here. People say a harsh lockdown at a given point in the pandemic, when it brings numbers down and does so successfully, that after that we can keep up the society for a considerable time, is actually, in terms of economy, less damaging than a half-hearted lockdown, but that needs to be very long. So there's some kind of economic optimization going on. And to some extent, a lockdown is harmful for the economy, but in some sense, a lockdown may actually prove helpful for the economy. But now, this is, I think there's some truth to that, I think, but I'm not an economist, and you have to be an economist to judge that properly. But of course, this is all a moving target, because it does not take into account that variants of concern appear that are more infectious. So you make a lockdown and you think you're done, but you have to make another lockdown or make the lockdown longer than you initially assumed. So this is, I must leave this to the economists to make plausible arguments here. But this dimension is there too.
Muchas gracias, profesor, por su respuesta. Retomando alguna frase de esta última exposición de su parte, usted menciona la necesidad de establecer prioridades, ¿no? En el marco de un test de proporcionalidad, de un examen en el que tenemos que decidir sobre diversos principios constitucionales en juego, ¿cómo establecemos la prioridad? Tanto especialmente en abstracto, ¿cómo establecemos la prioridad? ¿Qué elementos de juicio para tomar esta decisión podemos tener entre distintos principios constitucionales? Por ejemplo, ¿cómo establecer qué tan importante es el derecho a la salud o a la vida? ¿Cómo valorar qué tan importante puede ser el derecho a la libertad religiosa? ¿Cuáles son los referentes para esta estimación? ¿O no podemos determinar esto? Y aquí tomamos una vieja objeción a la proporcionalidad, la objeción de la inconmensurabilidad en relación con la proporcionalidad y esta posibilidad de medir los derechos fundamentales y los principios constitucionales. Gracias.
Yeah, thank you. How could I dare to give you an abstract ranking of constitutional values if the Constitution itself does not do it? I understand that this is a pressing question. I understand. Yeah, well, little digression. It just sprang to my mind that we might speak of a direct competition, for example, right to protection and religious freedom, right to protection and right to assembly, right to protection and freedom to pursue one's business as one wishes. These are the direct competitions, and the protection is always on one side. But there's an indirect competition when it comes to deciding on priorities in this comprehensive bundle of measures. So should we have a higher reduction of social contacts in the business area compared to schools, because the right to education is more important than economic activity. This, so to speak, the competition, which liberty is left most unharmed in this comprehensive bundle of measures. This is an indirect competition, but it is there. And this prioritization, I think prioritization is an expression that captures both aspects very well, expresses these two things. Now, there are two clear things. The Constitution typically does not give a formal ranking of abstract weight of constitutional rights. It just records them one after the other. They are mentioned. And there is nothing in the Constitution that from which we can infer typically which are more important and which are not. This might be different to some extent with the general right to liberty in Germany, which is so huge and so unspecific that it is perceived as having an abstract weight. And there is, on the other side of the spectrum, human dignity, which is considered as a constitutional right, actually, with all sorts of question marks, which it has priority over everything, but it's very difficult to say what it is. So it is very difficult to say what precisely has this priority. Now, when it comes to all the other, this long list of constitutional rights, which are just mentioned one after the other in the Constitution, there's not much we can derive from the Constitution. And on the other side, we know that if it comes to a concrete competition, if there is COVID, and it would be good to close the school because infections are prevented. It would be bad to close schools because the children get no education. If there is, in this very concrete situation, a competition, we have to take a decision. And then the question is, and formally, if we do balancing, proportionality balancing, these prongs that I mentioned, suitability, necessity, and balancing. And in balancing, the structure of balancing that is reflected in what Robert Alexi calls the weight formula. This is only the structure. What we need and what would be the appropriate answer to that question is a system or a theory, you could say, of the justification of the weight in balancing. And that is something that has not received much attention, but it is now beginning to receive attention. And that is the so-called external justification of balancing judgments, as opposed to the internal justification, that is the structure, the logical structure or mathematical structure in which a conclusion follows from the premises. But you need to justify the premises. This is the theoretical side. The practical side is read as many precedents as possible, because what courts do, if they do not only rely on the formal authority of their judgments, if they offer a substantive justification why, in this case, this constitutional right had priority over the other, you find arguments. And so an analysis of precedents at least gives you an idea of the aspects that are considered relevant in justifying why in a concrete competition, in a concrete case, one fundamental right has priority over the other. We do this very naturally, actually, and you will not find very surprising things here. The only thing is to systematize that which is already ingrained in our interpretive practice if it comes to constitutional rights, which is also in some kind of connection with the positive morality we have. If you have societies that value children education very much, they will never close the schools. The factories are closed, the pubs are closed, the concert halls are closed, but not the schools. If we have other societies who have other priorities, this will be reflected also in their set of precedents of their constitutional court. So this answer is not fully sufficient, but I think it's at least points to what we need to do in the decades to come.
Muchas gracias, profesor. Abundando en su respuesta, si fuera tan amable, por supuesto hay ciertas ideas morales más o menos compartidas, más o menos consensadas en la sociedad, ciertas valoraciones que pueden ser muy evidentes o contra las cuales no hayan objeciones relevantes, como por ejemplo queda claro que el derecho a la vida es mucho más importante que otras, como el derecho de propiedad u otras cosas. Pero para esta valoración y esta estimación de los principios constitucionales, pueden ser útiles elementos como las fórmulas textuales de la Constitución o los precedentes establecidos por el Tribunal Constitucional. Gracias por su respuesta.
Well, textual evidence, precedents, and their connection with shared moral ideas. Yes, they are relevant because, of course, also a constitution did not fall from heaven at some point, but a constitution was recorded by a constituent assembly, often following some kind of national assembly and an election of the delegates who would then create the constitution. So the constitution already is influenced by shared moral ideas at that time. And they are reflected in the constitution insofar as there are such kind of reflections. Often there aren't any reflections, it's simply left open completely. And then nothing is fixed. Problems emerge, of course, if the constitution reflects shared moral ideas which have become over time outdated in society, because then a tension emerges. And technically, you would need to amend the constitution. This would be the, so to speak, proper way legally of doing it. But constitutional amendments are often require political compromise, and those who want it most are faced with others who don't want it so much, but then ask for favors completely unrelated to that, to say yes to that amendment. So it's very burdensome. And as a matter of fact, unfortunately, then some shared ideas are just reinterpreted against the wording, simply ignored the interpretation. It said, well, this is old and outdated, we don't need it anymore, which is a bit dangerous because it places the binding nature of the Constitution into perspective. I'm a fan of the binding nature of the formally enacted Constitution, because if you don't respect it, then if there is a political controversies, then you just say, well, what the Constitution says is basically not what we need to do. It's just a starting statement, but when we have good reasons, we just ignore it. That is not a good idea. In this sense, textual evidence in the Constitution, yes, even legislation, of course, is an expression of societal values, because the legislator usually has democratic support, because the majority in parliament who decides on legislation is enacted, is in office because of a democratic election, and you would expect that the representatives, the members of parliament, the representatives, actually represent the people and the moral views they have. And precedents, yeah, this is something, I think, legal argumentation, which is now mentioned for the third time, has not been very good, I think, to date, to capture what I would call the influence of positive morality, of the shared beliefs in society, the role of positive morality in actually court judgments. We tend to neglect it. We just assume judges have, they are bound, and then they have some room of discretion where they can decide, and they have some reasons, but we don't ask too much what these reasons are. Positivism, non-positivism is a debate, but above that, there's not much questions asked. And I think many judges feel an obligation. They do not just put their own moral views and ideas into their judgments because they are legally, technically admitted to do so, but actually they feel that they represent the population and take care a good bit what the population thinks. And so in that sense, I would say that the whole legal system, the written constitution, statutes and judgments, and also the interpretive practice which connects these things, everything reflects basically shared moral ideas. And if you do comparative law, you will find that in different legal systems who are not close neighbors, but who are actually from other continents, that in some cases there are quite some other moral ideas. And the society is working too. Yeah.
Muchas gracias por la ampliación de su respuesta, profesor Borowski. Hemos llegado lamentablemente al final de esta charla tan fructífera, tan interesante con el profesor Borowski. Quisiera pedirle, profesor, si usted quisiera decir alguna conclusión general sobre todo lo que hemos conversado en esta ocasión, le agradeceríamos que nos honrara con un panorama, con una conclusión panorámica de lo que hemos conversado. Muchas gracias.
Well, because there were so many interesting and valuable questions, there's not much left in terms of substance that I would like to share with you. It has become apparent, something else I want to say, but very briefly. It has become apparent that this pandemic is actually a challenge from the legal point of view, a challenge for the political system, a challenge for solidarity to some extent when it comes to vaccines and other distributive efforts. And the only thing I want to say today, following my last lecture in this series, is that I wish you the very best in Mexico, that you get as good as possible through the pandemic, that the pandemic does as little harm as possible, and that the pandemic and the fight against the pandemic at the end of the day has the result that the people actually come together and work together, and that not existing this or that existing difference is more pronounced than before. So basically I want to do is here at that point in time send you just the best wishes for the future in Mexico. Thank you.
Muchas gracias, doctor Borowski, por sus fraternales palabras y sus deseos tan cordiales. Muy agradecidos por esta expresión de buena voluntad. Lo mismo creo que deseamos para usted, su familia y Alemania, que es un país muy estimado. Con esto concluimos esta charla en esta sesión del conversatorio sobre la restricción de derechos fundamentales en la pandemia por COVID-19. El Centro de Estudios Constitucionales de la Suprema Corte de Justicia de la Nación les agradece a todas y a todos su asistencia y su atención a esta tan interesante charla. Y nuevamente, muchas gracias, profesor Borowski, por compartirnos su tiempo, su conocimiento y su amistad. Muchas gracias. Que tengan todos y todas muy buenos días en México y muy buenas tardes o noches ya en Alemania. Hasta luego.
Hola, buenos días a todos. Ya estamos en cortinilla. Vamos a hacer el cambio al siguiente ponente.